Hello everyone, I am Professor Kevin Bell, the Director of the Castan Centre for Human Rights Law in the Faculty of Law at Monash University. It is my great pleasure today to be interviewing Professor Emeritus Mick Dodson, AM, who is the Treaty Commissioner for the Northern Territory Treaty process. Professor Dodson is responsible for the early stages of this process, which is designed to examine whether there should be a treaty or treaties entered into between the Indigenous peoples of the Northern Territory and the Northern Territory government. I want to begin by acknowledging the Indigenous peoples who are the traditional owners of the land on which we are now meeting, which will be very many in number. But in my case, the people are the Boonwurrung people of the Kulin Nation, and I pay my respects to their elders, past and present. Professor Dodson was born in the Northern Territory. He was born in Katherine, but in fact, he's a Yaru man. His traditional country is in the area around Broome in the southern Kimberley. It would take me a very long time to introduce Professor Dodson if I were to refer to all of the distinguished contribution he's made to the Indigenous and wider community in Australia and indeed internationally. Perhaps it's important for me to mention in the present context where we're talking about treaties and self-determination that he played an important role along with many other Indigenous Australians in the formation of the United Nations Declaration on the Rights of Indigenous People, which was passed by the United Nations General Assembly after a 20-year gestation period, perhaps even longer than that in 2007. Mick, for many years, was a Professor of Law at the Australian National University and still is so. He's an Emeritus Professor and was the Director of the National Centre for Indigenous Studies before becoming the NT Treaty Commissioner. But before all of that, he and I have one small crossover a very long time ago, and that is that he graduated in 1974 as the first Indigenous Australian to graduate in law from an Australian university, and I began in that faculty my studies in law as a younger person, not 1 year earlier. And so it's a special pleasure for me, Professor Dodson, to be interviewing you today about a subject that I know is close to your heart and is certainly close to mine. I want to take one free question. I think as the interviewer, I get one free question, and this is it. I'm really interested to know what it was like for you back in those days, so long ago, in the early 70s as a law graduate in the Faculty of Law at Monash University.
Oh, hello everyone, and thanks for, I can't say for having me on your show. I don't think it's quite the same thing.
No, I don't think it is.
But it's good to be back at Monash in a spiritual sense, if not a physical one, way up here in Darwin. Monash was probably the hotbed of radicalism in my day when I started there in 1970, and I was in the draft for Vietnam that year, as were many of my colleagues. There was always something happening on campus. University education was free, of course, in those days, and you know, go down to the Notting Hill Hotel and for $2 and buy a 25-cent schooner of beer and come home legless with $1.50 left in your pocket. But it was a very interesting place. And Monash, the David Derham School of Law was the first one, I think, in Australia. There weren't many schools of law in that day. I think there was
Only one other in Melbourne, if I'm not mistaken.
Yeah, the Melbourne Uni and Monash, and I think one in every other jurisdiction. But it was, they were heady days, as they say. And I mean, the thing about Monash, because it was young, I mean, my first year there was the first year they had law graduates. So it was a very young university, had very young lecturers, professors. I think they were. I met the tutors were young. Everybody seemed to be young.
Everybody seemed to be young.
And we had some incredible people. Louis Waller was he was a professor of law at 33, which was unheard of back then.
Yes.
So he's very young. I think he and there's another fella who was 27. They were the youngest law professors in the country.
Yes.
Yeah. And they were brilliant people, of course. And there was some brilliant female lecturers as well, and professors.
Yes, I understand.
Professor who taught me property law was pretty flash.
Yeah.
It was very good, but it was hadn't sort of built a tradition really at that stage. It was just a new young university, but had some really great ideas.
Sounds like you actually got a lot out of it and were quite inspired by it.
Yeah, we did things like landlord and tenant law. That was unheard of.
Yeah.
We did legal aid. We did. We had the Springvale Legal Centre as the sort of experiential clinical training that you don't normally get at in a classroom, in a lecture theatre. It was, we did things like the administration of criminal justice, which is a different way of looking at not just learning about the criminal law, but its administration, which is fabulous. Because I went from uni to Aboriginal legal aid, so that was very handy having having those sorts of things, But it was an exciting place to be.
Thank
and
you,
I eventually somehow got through.
Yeah, I think we can all see how. Now, I think before we move to the NT treaty process, a bit of foundation laying might be in order, and there's a pretty obvious foundation to go to straight away, which is UNDRIP, the United Nations Declaration on the Rights of Indigenous People. UNDRIP specifies a right of self-determination in relation to Indigenous peoples. Can you talk with us about what the meaning of that right is, as you understand it to be?
Yes, well, the UN Declaration on the Rights of Indigenous Peoples generally doesn't create any new or distinctive rights. It takes existing rights and puts them in an Indigenous context. There's nothing in the declaration that is new or different to the rights that any other group of people enjoy, and neither is the right to self-determination. It's almost exactly worded from the two covenants.
Yes,
and it's it just has a reference to Indigenous people, that Indigenous peoples are entitled to the right to self-determination, to politically organise, to work out their political status, to have control over their social, cultural, economic development, like all other peoples do. I got involved in the mid-'80s, I think, when I was working as senior legal advisor at the Northern Land Council, and we got into the habit of going each year to the Working Group on Indigenous Populations in Geneva in the Palladium Nations in
Yes.
the UN headquarters in Geneva. And
Yes.
in that process, I think altogether took about 23 years.
I think it did.
And it had direct input from thousands of Indigenous people over those 23 years from around the world. And lots of Australians, Aboriginal and Torres Strait Islander people, were part of the process of elaborating the declaration. It was probably the first time in the UN where the people who were the subject of a UN instrument relating to human rights were directly involved in its elaboration. Which
when you engaged in that process with Indigenous peoples from other countries, did you feel that you had common cause with them?
Yes. I remarked at one stage when I had to, after I went to, I think it was my first visit to Geneva in the mid-80s, I had to report back to the full council of the Northern Land Council where I was working at the time. And I said to people, at the council members, look, you could close your eyes and listen to the headphones, ignore the various languages that you're hearing.
Yes, the accents and languages.
Yeah. And you could be at a meeting at home because the issues and the problems and the aspirations, the dreams were exactly the same in Central Africa and Central America, in Asia, in the Sami lands in the north, the Inuit people of Greenland. They were dealing with exactly the same stuff that we were dealing with in Australia. So there was a commonality of experience that was really, in fact, sort of made you feel at home.
At home,
made you also feel that, God, in Australia, we're not alone.
No.
There are all these people around the world grappling with the same issues we're grappling with. And there was a sense of
solidarity,
camaraderie, really.
It was more than solidarity.
It was
a mutual
witness
support
together sort of thing. And of course, there are regional variations and stuff, but the issues were the same, remarkably the same.
It's interesting when I asked you about the formation of UNDRIP and what self-determination means to you, that you immediately made the point that the instrument does not specify anything different for Indigenous people that other peoples have. And I've seen Indigenous leaders make that point before. I mean, I remember speaking with Les Malazer about exactly the same thing. And he made that point very strongly, just like you did.
Yeah.
Why is it important to make that point that in that instrument, there are specified things that other people have that you now have as Indigenous people?
Yeah, there are some who oppose Indigenous people's rights and place in the world, really. They'd like to paint it as something different, something special, something discriminatory even.
Yes, something
favourable. That Indigenous people are getting benefits that other people aren't within nation states, which is just rubbish.
Yeah.
The right to self-determination is in Article 2. Article 3 sets out a possibility of self-government for Indigenous people as a form of expressing self-determination.
Yes.
And most of the people, there were a few groups where they were actually taking up arms against their colonisers who would turn up at the United Nations, but most of the Indigenous groups were looking to internally to self-determination.
Yeah.
Some sort of a domestic version
Yeah.
of self-determination. None of us were equipped or silly enough to say we want to break away from the United States or Canada or Australia or New Zealand, you know, to put the Kansas group together, or even the Inuit. You know, they weren't saying we don't want to be part of Russia or part of Canada or part of Alaska or part of Greenland. They were saying essentially, and the way in which I tend to try to explain self-determination to Aboriginal people in Australia is that people want to control, want to make those decisions, control and make those decisions that mostly affect them, their families, and their group, particularly on a daily basis. You know, the decisions that are made about where they live, what sort of house they have, how they can use their own language. Transmit that, preserve and transmit their culture, to look after their traditional country, to be respected and enjoy who they are, and to make the important decisions themselves, not have decisions made by people who may have their best interest in mind, but really don't make the decisions that they would make. You know?
Yes. Thank you.
And it's, you know, in the end, it's being in control of your destiny.
Yes.
That doesn't mean to say you have to be separate from the rest of the country. What it means to say is that you've got a right to social justice, and in the end, self-determination and social justice means what hits you when you get out of bed in the morning.
Well, let's move now to the NT treaty process. Your functions are governed by the Treaty Commission Act of 2020. And I think perhaps we should begin with what your functions under that act actually are.
Yes, well, the terms of reference require that we report. We've got a two-part process. We had to produce an interim report. We did that in March this year, and we had to produce a discussion paper, which was delivered to the Chief Minister of the Northern Territory and the chairs of the Northern Territory Land Councils in June.
And a very impressive document it is.
Yeah. So we're now, the second phase is to consult on that discussion paper, consult Aboriginal people on the discussion paper, and produce a final report that's to go to the Chief Minister by March, early March 2022. So, and what we've got to do is report on, firstly, whether Aboriginal people want a treaty or treaties.
Yes.
We haven't so far, and mostly we've been doing education awareness raising with peak organisations across the Northern Territory. Up until January this year, we'd talked to 50 plus organisations, their representatives, all the land councils, the 4 land councils, major organisations, legal aid, the health services, community organisations that delivered like local government services and things like that. We haven't had anybody say they don't want a treaty or treaties.
Mm.
That's another question in our terms of reference. We have to report on whether people want a treaty, a single treaty, or multiple treaties.
Yes.
And the answer so far is, having spoke to those 50 organisations, is people want multiple treaties.
Multiple treaties.
Yeah.
With a template hanging over the top and treaties underneath?
Our idea we've been suggesting to people is that there's a framework, a legislative framework, that sets the rules, sets the standards, and allows for, under that umbrella, allows for local treaties. So individual First Nations can make their local treaties under the framework which entrenches the Declaration of the Rights of Indigenous Peoples standards as the minimum standards.
Yes, I understand.
We have to, that's part of our terms of reference, is to suggest a framework, suggest minimum standards, and suggest a process of how, what might go into a treaty, how the treaties are to be negotiated, et cetera, what the content of treaties might be. And we also had to provide legal advice to the government about any legal and constitutional issues that might be problematic for the Northern Territory being a territory and not a state in entering treaties with Aboriginal groups or First Nations, as we prefer to call them.
Call ourselves.
So, there's that research. I wouldn't have the legal advice. The legal advice says there's nothing that would prevent the Northern Territory from making treaties with
exercising its normal plenary power to make laws with respect to the benefit of people in the territory.
Yes. But the Commonwealth governments over the years, particularly since self-government in the Northern Territory, because from 1912 to 1978, the Northern Territory is administered by the Commonwealth, and they made all the laws for the Northern Territory, and they've got enormous power under Section 122 of the Australian Constitution. Really, they can do whatever they like.
Yes.
Yeah. And they have done that in the past. The most recent is the intervention. There's the assisted dying, all sorts of legislation that's been outlawed by the Commonwealth. But we've had a situation where the Minister for Aboriginal Affairs, the present Minister for Aboriginal Affairs, has written to the Chief Minister and given him some comfort about the process.
Yes, I see.
So that's useful to have that, but the Commonwealth is less likely to interfere with processes like this that states undertake.
Yes.
But they still have the power to pass inconsistent laws that'll override state laws and certainly territory laws. But governments aren't really bound by what previous governments have put into law.
No.
And many of them have a tendency to get rid of the previous government's laws that they don't like. So there's that, but we think on balance that because all of none of the political parties at the recent election said they opposed treaties, so they all support the treaties. So it's 1/3 of the voters in the Northern Territory are Aboriginal.
Yeah.
So it makes political sense.
It's a political sense as well.
Yeah. So we're gonna go ahead with what we're doing and make sure that what we're suggesting is both consistent with the Constitution and the Commonwealth laws, and also with Northern Territory laws.
The subject of truth-telling perhaps is one that we should cover directly. I remember being an intern in a native title case under the Northern Territory legislation in the late 70s, just after I left university. It was in the area around Mount Sterling at Coniston Creek. This was the Walpurgis claim, I think, but I might be wrong about the people. The case was actually conducted in the creek where a terrible massacre occurred, the Coniston Creek massacre in the earliest 20th century. Is truth-telling about the many kinds of such events an important part of the treaty process? And how do you intend to go about making recommendations in relation to addressing that issue?
Yeah, we identified it as a very important part of the treaty making process. Deal with what we call unfinished business. We need to do that if we want to go forward. I was actually involved as a young barrister, invited to the Walpurgis Cottage land claim under the Northern Territory Land Rights Act.
Yes.
In the early 80s, 1981, I think it was. And heard evidence from a couple of young, I mean, they were old people, at that time, but they were young children who were present at
really?
the Coniston massacre.
I see.
The hearings are out at Ali Karung. And I recently drove from Yuendamu to Ali Karung through what they call the back road, and past not far from the Coniston site. John Toohey was the commissioner, the land commissioner in that case. And they had a commemoration there last year, I think.
I see.
Might have been the year before. Anniversary, but it, it's the most recent recorded, acknowledged massacre anywhere in Australia. And it happened under the after Federation and under the watch of the Commonwealth.
And there were living people were able to talk about it.
Yeah, and those stories have been handed down, and people still talk about those as it's Aboriginal oral traditions are very strong.
In terms of if we see treaty making as the manifestation of a relationship between peoples, and the commencement of a relationship of respect based upon people coming together after something has happened. I'm thinking of the concept of Makarrata, obviously. But what's the significance of telling the truth about events that happened to the prospects of success of a new relationship commencing and being successful under a treaty process?
Yeah, it's you can't move forward until you deal with this pain and anguish and hurt. And it's not just the fact that people were murdered and slaughtered. There are other terrible things that happen. Children were taken away. Children were belted for talking their language. Their parents were lied to, particularly mothers. They were punished for being Aboriginal. And there's a lot of those people in the Northern Territory are in their 80s, and some are in their 90s now. But they've got children and grandchildren, great-grandchildren, and great-great-grandchildren. Sure. One of the things we identified, or which psychiatry and psychology, psychologist identifies, is what they call intergenerational transfer of that trauma, And so there are people still hurting. Although they weren't physically taken away, their parents were, or their grandparents were, and their whole behaviours and development have been affected by what happened a long time ago. Well, not that long time ago. And there's also people who are survivors of slaughter, where their relatives were killed. And those stories have been handed down. There's stories about people being treated terribly as slaves on pastoral leases, particularly in the cattle industry, along the coast in pearling and other types of industries, in towns, where people were essentially enslaved. Yeah.
Yes.
So there's a lot of bad stuff that happened that you can't go forward unless you have some resolution of that. You're never ever going to get rid of it completely. But we have to deal with it as a nation. It's a terrible aspect of our history, our shared history, that we can't go forward unless we deal with it. So that's what truth telling's about. And it's not an unknown new thing. It's been happening around the world. We will soon be putting out a short discussion paper on truth telling that we hope will get some feedback, and we'd include our ideas and suggestions for how a truth-telling process might begin. But we think it's got to start soon, because a lot of these people are leaving us. They're dying.
They're dying, yes.
And
so there's an urgency.
I mean, there's a big project being led, I think, by Lyndall Ryan at the University of Newcastle that's documenting nationwide massacres.
Yes.
And as I said earlier, the last one that's known and acknowledged happened in the Northern Territory less than 100 years ago.
Thank you.
And I mean, it's a treaty. It's part of a treaty process, because there's an Aboriginal woman in Canada, in British Columbia, who's a prominent leader there, who said that I've forgotten her name for now, but she says dealing with this stuff it doesn't constitute a divorce between Aboriginal people and non-Aboriginal people. It actually should be seen more as a marriage than a divorce. A treaty is more of a marriage than a divorce. And I'd like to look at it that way as well, because it's about coming together, not about falling apart.
No. A brief diversion, if I may, after that difficult subject, onto something lighter. And this is the subject of native title. Well, that's hardly a light subject, is it? As you know, the Castan Centre is named for Ron Castan, AMQC, the lead counsel in the Mabo case. And I had the honour of being the lead counsel for the Yawuru, your people, in their native title case. And I'm certainly not comparing Yawuru with Mabo, far from it. But I am wanting to speak with you about the significance of native title from the point of view of self-determination, because you witnessed as a Yawuru a long process of dispossession, particularly because Broome is such a critical point in the geography of the western part of the nation and the intersection of so many important song lines and cultural traditions. Was very important and to protect what remained from the process of colonisation. And there was some success achieved in that case. And I'm wondering whether you can say something about the significance of native title from the point of view of that success to self-determination, and what it meant to you personally to see that happen.
Well, first, I thought the judge or the court was wrong about the bit we didn't get.
Yep.
I mean, the thing about native title, it gives native title holders agency in what happens to them, their culture, their language, their people, and their land. And it gives you some leverage to be in charge of your own individual and group development, human development. One of the things native title has taught us, which is essential to treaty making, is that you have to be unified. Disunity will be deadly to treaty making by groups, or as it can be with native title claims. It doesn't mean to say you have to agree on anything, but the important stuff has to be sorted before you get to the table, or before you get to the to the court.
So you've learned something about process from participating in these.
Yeah, but the thing about native title, people are using it. Like I mentioned agency, they're using that agency to be very inventive and innovative and clever about how they use their native title. And wonderful things are happening.
Can you give me an example?
Oh, well, you know, most places now you've got Indigenous economic development like you've never had before. I mean, we have, I don't know, I think it's about 5,000 parcels of land in our settlement. And there's over 3,000 of them in the town of Broome.
It's a big deal.
And we've taken, you know, we've agreed to extinguish from the native title. I don't think that should happen. And Canada's got rid of the idea of extinguishment of native title, particularly in British Columbia. But we've taken freehold for those blocks, and the native titles are meant to be like freehold, but financial institutions aren't that willing to lend for long-term leases, you know, long-term leasehold. Although, you know, I own a house in Canberra, and it's a leasehold block. It's worth a fair bit of money. And all of Darwin, up until self-government, all the towns in the territory really were up until self-government in 1978 were all leasehold. So, and people bought and sold the leasehold.
The leasehold, yes.
So it gives you economic leverage because you've got land, and a lot of our estate, if you like, is reserve land. And we've got a whole coastline, 120 kilometre coastline that is partly marine reserve, you know, foreshore reserve. And, but it gives us an opportunity in particular to establish an economic base that you can do other things with.
Yes.
And we put a lot of emphasis on our language and culture.
Culture.
That's, one of the first things we did. I mean, and there's a strong revival of language, which I really support. And this is not just us. There are other groups around the country. And you look at what happens in Aotearoa, New Zealand, where they are renegotiating for settlements of breaches of the Waitangi Tribunal with different iwi, different First Nations groups. And they're becoming economic powerhouses. I mean, the Ngāi Tahu in the South Island, they own most of the South Island, except for a strip up the north of the South Island. they're an economic power.
Yes.
They have huge investments.
Mm.
If you go on a tour in the South Island, it's like those tours are run by the Ngāi
Yes, those people.
Yeah.
Now, the Northern Territory has very significant native title ownership by First Nations people. What will be how will a treaty interact with native title as legal institutions?
It's going to take a lot of negotiation.
Yes.
There are 4 very strong land councils in the Northern Territory, 2 on the mainland, and the Tiwi Islands and the Groote Island archipelago. They've got powers under both the Native Title Act and the Northern Territory Land Rights Act. The proposal we're putting for, or the suggestion we're putting for treaties is that there has to be an array, from a legal point of view, an array of side agreements, particularly on Aboriginal land, which is what they call land rights land, because of the functions and powers of the land councils under the Land Rights Act, because nothing really can happen on Aboriginal land without the land councils protecting what the traditional owners want. The suggestion we're putting is that the governing, the polity in a government model for Aboriginal self-government model for treaties is made up of the traditional owners. So in effect, the land councils have to ascertain and express the wishes of the traditional owners on what happens on their land, and if they are the entity that's wanting some sort of self-government treaty position, the land councils ought to be supporting that. And I mean, from the beginning of the treaty process, it was driven by the land councils anyway, so on behalf of the traditional owners.
Yes.
But and there's not as much control under the Native Title Act by the land councils, but they're the representative bodies for
the bodies. Yes.
Yeah, for the native title holders.
Mm.
And there's enormous, there's 50% plus of the Northern Territory is owned by Aboriginal people, either as Aboriginal land under the Land Rights Act or native title under the Native Title Act. And 85% of the coastline is now Aboriginal owned, at least the intertidal zone, because of the Blue Mud Bay case.
Yes.
And there's been a lot of native title extinguished. And of course, we have the Timber Creek case, which declares what is payable on just terms.
Yes.
For the extinguishment of native title.
Right.
So we're saying to those who want to listen in government, it's probably better to negotiate a treaty and settle these matters rather than litigate them. And the Blue Mud Bay case is almost 12 years ago. Timber Creek's more recent, of course. But, those things need to be resolved.
I'm not sure that I appreciated that native title had such a positive connection with the concept of treaty, not necessarily conceptually, but from a practical point of view, how Indigenous peoples, the First Nations, participated in the process procedurally, prepared the way, and then aspects of native title gave First Nations people control, indeed ownership, and the potential of getting more, which increased their hand in claiming treaty as a possible way forward, and indeed in the treaty making process itself. Would you agree with that or not?
Yeah, well, two things I'll say about that is, firstly, people like George Williams and Harry, I've forgotten Harry Hobbs is saying that the Noongar native title settlement is in effect a treaty.
A treaty.
And what's happening in British Columbia? The new treaty making in British Columbia are actually settlements of native title claims.
Yes.
There's wonderful scope there for treaty making. There will be future native title claims. There ought be nothing stopping parties from going back to those agreements, mainly government and native title holders, and recast again them as treaties.
Yes.
Particularly, I say, in light of the Timber Creek case, and for those people who've got coastal land, the Blue Mud Bay case. There needs to be a willingness, and there's a willingness in the Northern Territory. I mean, we have an agreement from the Territory government with the land councils. It's scheduled to the legislation setting up the Treaty Commissioner's position.
Yes.
That the Northern Territory government accepts that Aboriginal people of the Northern Territory were the owners and occupiers of the land and waters of what's now known as Northern Territory, that they were self-governing well before colonisation. And thirdly, and importantly, Aboriginal people have never ceded their sovereignty over those lands and waters. So it's a good place to start in this sense, because we don't have to have that debate.
No.
And I think what that allows for Aboriginal people in the Northern Territory and the government of the Northern Territory says, all right, we accept you haven't ceded your sovereignty. What does your jurisdiction look like?
Yes.
And the Aboriginal people say, well, that's a matter for us to negotiate. And that negotiation will be the treaty negotiation. That'll resolve
that will define the space within which that sovereignty can be exercised?
Yes. That's the rationality of it anyway.
Yes.
Yeah. So it doesn't, it's not going to affect the sovereignty of the Northern Territory or the Federation. But Aboriginal people will get a final settlement of having the right to say what they want to do, not what someone in Darwin or Canberra want to do.
Professor Mick Dodson, thank you very much. I'm aware that you've got another meeting to go to. I think we need to finish up now.
And it's been a pleasure, and I hope someday we can
meet in person.
And in normal circumstances, I'd love to have come down and given a seminar or a lecture in person. But let's see what happens next year. I've still got my connections with Monash.
You most certainly have, and take this as an open invitation to do just that. I want to thank everybody who's been listening to this fascinating interview with Professor Mick Dodson, the Northern Territory Treaties Commissioner on the treaties process in the Northern Territory. and much else besides. It just remains for me to give you my most sincere thanks, Mick, for sharing your thoughts with us, and to wish you all the best for the treaty process which you are undertaking.
Yes, and thank you very much. And we would welcome submissions from
yes,
whoever wants to put one in.
And one needs only to type into a browser Northern Territory Treaty, and your website comes up #1 with an excellent discussion paper being able to be accessed there.
Yeah, and there's other documents on the website as well and audio recordings in 18 different Aboriginal languages. If you speak one of those, you'll completely understand what we're talking about.
All right then. Bye for now.
Okay, thank you.
Bye.
Galia.
Galia.